Good morning, everyone. We're down to the last two meetings in this lecture series on the rules on criminal procedure. This morning, we're going to discuss about new trial and reconsideration under Rule 121. Okay. Now, what is new trial? And let us distinguish it with reconsideration. These are actually these are remedies of the accused. Now, after judgment. So a new trial is a rehearsal of a case already decided, but before the judgment of conviction therein rendered has become final. So before finality of the judgment, the accused can file a motion for new trial. A new trial will rehearse the case already decided, whereby the errors of law or irregularities are expunged from the record, or new evidence is introduced, or both steps are taken. On the other hand, a motion for reconsideration is filed in order to correct some errors of law or fact in the judgment. It does not require any further proceeding. Now, there are two grounds in a motion for new trial. There are errors or irregularities prejudicial to the substantial rights of the accused that have been committed during the trial, and there is new and material evidence has been discovered. So either of the two, it's either that there is an error of law or irregularities which is prejudicial to the substantial rights of the accused that was committed during the trial, or if there is a new and material evidence that has been discovered. A motion for reconsideration, on the other hand, is an error of law or an error of fact. So these are the two grounds of a motion for reconsideration. Again, error of law or error of fact. No? In a motion for new trial, the new and material evidence has been discovered with reasonable diligence, okay, and produced at that it could not have been produced at the trial, and which, if introduced and admitted, would probably change the judgment. So other grounds which the court may consider in the exercise of its jurisdiction: negligence or incompetency of counsel, or mistake, which is so gross amounting to deprivation of the substantial rights of the accused and due process. So if there was an incompetent defense, for example, the some vital evidence on record were not presented by the defense counsel or counsel for the accused, and such negligence, which is so gross in character, deprives the accused of his substantial rights to due process, then the accused can file a motion for no trial. Recantation of a witness where there is no evidence sustaining the judgment of conviction other than the testimony of such witness. If the motion for new trial is based on newly discovered evidence, it must be supported by affidavits of the witnesses by whom such evidence is expected to be given, or duly authenticated copies of documents which it is proposed to introduce in evidence. Now, recantation class is a public and formal withdrawal by a witness of his prior statement. When you say recantation, the witness is retracting, recanting, or withdrawing his previous statement with a new one. Now, what is the distinction between a recantation and a desistance? A recantation is where a witness who was previously given a testimony subsequently declares that his statements are untrue publicly. No? Whereas in an affidavit of desistance, the complainant states that he did not really intend to institute the case and that he is no longer interested in testifying or prosecuting the case. So this is the distinction. In recantation, it is the witness who was previously testified now withdrawing his statements because they are untrue. In affidavit of desistance, it is more on the intention of the complainant in prosecuting the case. For example, if the institution of the criminal complaint is due to a mere misunderstanding and that the complainant is no longer interested in instituting the case, then you file or you draft an affidavit of desistance. Okay. As a general rule, a recantation is not a ground for the grant of a new trial and are hardly given weight. And then there is an exception. Now, when there is no evidence sustaining the judgment of conviction other than the testimony of the recanting witness, then recantation can be a ground for new trial. Now, affidavit of desistance is not a ground for dismissal of the action. It is merely an additional ground to buttress or strengthen the defense and not a sole consideration of acquittal. Just because a witness or the private complainant had already executed an affidavit of desistance does not mean that the accused will be acquitted or that the case can be dismissed, because the court can base its judgment on other evidence available, such as documentary evidence and object evidence. Okay. What is the effect in granting a new trial or reconsideration? In all cases, when the court grants a new trial or reconsideration, the original judgment shall be set aside or vacated and a new judgment rendered accordingly. In addition, when no trial is granted on the ground of errors of law or irregularities committed during the trial, then all proceedings and evidence not affected by such errors or irregularities shall stand. Those affected shall be set aside and taken anew, and in the interest of justice, the court may allow the introduction of additional evidence. On the other hand, in case that the ground for new trial is newly discovered evidence, then the evidence already taken shall stand, and the newly discovered evidence and other evidence as the court may, in the interest of justice, allows to be introduced, shall be taken and considered together with the evidence already in the record. Now, let us distinguish between new trial and reopening of the case. A motion for new trial is filed after judgment is rendered, but before the finality thereof. On the other hand, a motion to reopen the case is made by the court before judgment is rendered and in the exercise of its sound discretion. A motion for new trial is made by the court on motion of the accused or at its own instance, but with the consent of the accused. A motion to reopen the case does not require the consent of the accused, and it may be done at the instance of either party who can thereafter present additional evidence. So, okay. So there is a case decided by the Supreme Court on September 14, 2005, the Napes versus Court of Appeals case, more popularly known as the Napes Doctrine in criminal cases. Now, if the accused was convicted before the lower court and out of the judgment of conviction, he files a motion for new trial or reconsideration on the period of during the time of the period of perfecting an appeal, then a fresh period of 15 days to appeal is counted from the time of denial or from the receipt of denial of the motion for reconsideration or new trial. So these ends our discussion on Rule 121 or a motion for new trial or reconsideration. I'll see you again next meeting. Thank you.